So today's discussion topic is subsidiary legislation, the hidden backbones of the Malaysian legal system. So I am Zulaika, your host for today's podcast. So now, when we talk about laws, most people think of Parliament as of for the big debates, the acts, and also the major headlines. But what many don't realize is that behind every major law, there's a hidden framework that keeps our legal and administrative system running smoothly. That's what we call subsidiary legislation. To help us understand this topic better, we have an excellent panel for today. The first one is Ms. Farah, the legal expert who will explain what the subsidiary legislation means under the Interpretation Acts 1948 and also the 1967, and how it operates our system. The second one is Ms. Aini, who is the senior government officer who will share how delegated the legislation works in practice, from regulation to bylaws. So welcome everyone, so let's dive right in. Alright, let's get started. To begin with, I'd like to invite Ms. Farah Ashira to explain what exactly the subsidiary legislation and how it's defined under the Malaysian law.
Thanks, Ms. Zulaika. So my name is Farah Ashira, your legal expert. So let's dive right into it. So when we talk about the subsidiary legislations, we are referring to a really important parts of Malaysian legal system. So even though it often works quietly behind the scenes. So legally, Section 3 of the Interpretation Act 1967 defines subsidiary legislation as any proclamation, rule, regulation, order, notifications, bylaw or other instrument made under any act, enactment, ordinance or other lawful authority and having legislative effects. Section 25 also clarifies that any subsidiary regulation is deemed to be made under the Act. So that grants the authority. So this gives it the legal foundations and links it directly to the parent or enabling Act. Alright, let's break this down into simpler terms. So when we talk about the subsidiary legislations, it refers to law that made by the authorities other than Parliament, so such as government ministers, department or local councils. So these bodies receive their law-making powers from the Parliament through what is known as a parent act or sometimes it's called enabling act. So think of it like this. So Parliament is like the architect of the law. They lay down the big pictures like the framework, the principle and the objectives. So but the Parliament doesn't have the time or the expertise to figure out every little detail. So that's where the subsidiary regulation comes in. So it's like the builder who fills in the finer details. So things like specific safety rules, environmental issue or administrative procedure all built under the guidance of the framework Parliament created. So this system is what we keep our law flexible and up to date. So imagine if every small change like tweaking road traffic rules or updating the health regulations had to go through the full parliamentary process. So that could take months or even years. So by allowing the other authorities to make these detailed rules, Malaysian legal system stays responsive to new changes like shift in society, technology or public needs. So here the background on how this works within the broader legal structure. So in Malaysia, Parliament and the state legislative assemblies are the main bodies that are responsible for making laws. So they created a big laws, the Act and Enactment, so that set the overall rules for the country. But as things got more complex, from public health to financial to environmental issue, it will not be practical for Parliament to handle every detail. So for example, let's say there's an environmental disaster or public health crisis. Parliament might not be in session, but the government still needs to act fast. So this is where subsidiary legislation comes in, because it lets the relevant minister or department issues the necessary rules right away without having to wait the Parliament to meet. It's like giving them the power to act quickly when needed.
Does giving others the powers to make laws make the Parliament lose its all authority?
It's not mean like that. So, but here's an important point. So this doesn't mean that Parliament gives up its power completely. Instead, they delegate in a controlled way those who get the power to make laws to have stick to the rules Parliament has set out in the Parent Act. So, and their regulations must always match the original intent of the law. So, in simpler terms, Parliament creates the big law and subsidiary legislation helps bring them to life by adding the details that are needed to make those laws work in the real world. And of course, experts from different fields are involved in making these laws. For example, the environmental law. The Ministry of Natural Resources might create a regulation on pollution control. In health law, the Ministry of Health might set rules on disease prevention. So these ensure the laws are not just legally sound, but also accurate and practical for today's work. That's the beauty of subsidiary legislation. So it makes sure the big principles laid out by the Parliament actually works in practice and reflects the needs of society. That's all from me.
That was a great explanation, Miss Farah. Now let's move on to the practical side. Miss Aini, can you share why the subsidiary legislation is so important for the government daily operation? Maybe with some real life example?
Okay, first of all, thank you for inviting me for this podcast. Hello everyone, my name is Aimi and I am Senior Officer, Ministry of Housing and Local Government, which known as KPKT. So in my role, I oversee the development, implementation and enforcement of regulation and local bylaws, ensuring that policy passed by Parliament are translated into practical, effective rules on the ground. I like to talk about why subsidiary legislation is so important in Malaysia. Simply put, Parliament cannot manage every technical or administrative detail of every law. They focus on the broad principle and policy, but the specific, especially when it comes to highly technical or local matters, require expertise and faster action. That is where delegated legislation or subsidiary legislation comes in. So, why it is necessary? There are three main reasons. The first one is flexibility. Parliament cannot address all the details. Subsidiary legislation allows rules to adapt quickly when needed, whether it is an emergency or a technical update. The second one is expertise. It brings in specialists to design regulations that are practical and effective. Parliament alone may not have the technical knowledge. The last one is efficiency. It saves Parliament time, letting lawmakers focus on major policy while delegated authorities handle the details. We can see this in practice with some real-life example. For example, during the COVID-19 pandemic, Parliament set the framework for public health and safety, but the detailed rules like limits on gathering, travel restriction, and business operation were made through subsidiary legislation. This allowed the government to act quickly and respond to changing conditions. Another example is local bylaws, which cover traffic management, public health, water disposal, and environmental protection. Local councils draft this rule to suit the needs of their communities. Without subsidiary legislation, enforcement will be slow, inconsistent, and ineffective. Subsidiary legislation also ensures effective administration and implementation. It allows authorities to enforce law clearly, adapt them when circumstances change, and make them practical for everyday use. The inclusion of experts in the process also makes regulation more technically sound and reduces the risk of errors. There are also important controls to ensure accountability. The first one is consultation. Before any rule is put out, the authorities usually get input from experts or relevant groups to make sure the regulation actually makes sense in real life. The second one is Gazette publication. Every regulation has to be officially published in the Gazette first, so the public knows about it and no one can be penalized for something they were not aware of. The third one is parliamentary oversight. Even though these powers are delegated, Parliament still keeps an eye on everything to make sure the rules stay within the Parents Act intended. The The last one is judicial review, and of course, the court can step in and cancel any regulation that goes beyond its legal power or contradicts in the constitution.
Miss Aimee, can you share some example of cases that show how the subsidiary legislation actually works in practice?
There are several cases that illustrate this case well. The first one is S. Kulasingham vs. Commissioner of Land 1982. The court affirmed that Parliament is allowed to delegate legislative powers to ministry, departments or local authorities so they can create detailed rules needed for day-to-day governance. It explained that without such dedication, the government machinery will be overwhelmed as Parliament cannot practically handle every technical or minor administrative matter. The second case is Chon Hon Fat vs. Attorney General of Sabah 1981. The court ruled that any subsidiary legislation made must strictly follow the limits by its parent act, and if it goes beyond those powers, it becomes ultra-vires and legally invalid. This decision emphasized that while delegated legislation is necessary for efficiency and flexibility, it remains fully subject to constitutional limits and judicial scrutiny to prevent misissue. In short, subsidiary legislation is essential because it keeps our system flexible, saves Parliament times, and allows the government to act quickly when needed. Processes like consultation, gazette publication, parliamentary oversight, and judicial review ensure these powers remain transparent, accountable, and lawful. Without subsidiary legislation, Parliament will be overloaded, laws will be less effective, and administration will be slower. It truly is the hidden backbone of Malaysian legal system, quietly supporting governance every day.
Thank you, Miss Aimee. Before we wrap up, let's do a quick recap of what we have learned today. The first one is subsidiary legislation, as defined under the Section 3 of the Interpretation Act 1967, refers to the law made by the authority under the powers given by the Parliament. It allows our legal system to stay efficient, flexible, and responsive to the changing speed. We have also heard about how it operates under the Parents Act. The concept of ultra-vires means that any rules beyond the given power is invalid, and how real cases like S. Kulasingham vs. Commissioner of Law 1982 and also the Chon Hon Fat vs. AG of Sabah 1981 illustrate this principle. At the same time, our guest highlighted the importance of transparency, judicial review, and also the parliamentary control to prevent any abuse of the powers. So now, before we end, I'd like to ask each of the guests one final question. In one line, how would you describe the importance of subsidiary legislation?
So, in my perspective, I see that subsidiary legislation is the backbone that keeps our legal system flexible, ensuring laws remain practical and responsive to real-world needs.
Okay, for me, subsidiary legislation is essential as it provides the detailed rules and procedure needed to effectively implement and enforce primary legislation.
I see. Okay, thank you for all your insightful thoughts. To sum up, the subsidiary legislation is the unseen force that keeps the Malaysian legal and administrative frameworks running smoothly. It bridges the gap between the law and practice that will ensuring the governance remain both effective and accountable. As we like to say is, subsidiary legislation may work behind the scene, but without it, our legal system would stand still. So thank you for tuning in and see you next time in our next legal discussion.